Are you entitled to overtime, facing workplace harassment, or did you need to fire someone? Get the expert advice you need only on Toronto Speaks Legal Advice. Welcome to Toronto Speaks Legal Advice. I'm your host, Natalka Falkmer. Tonight, we're guiding you through the murky waters of employment and labor law with Sheryl Johnson and Stuart Rudner. Both Sheryl and Stuart are seasoned lawyers who help employers and employees proactively address workplace issues and understand their legal rights, duties, and obligations. Sheryl not only protects her clients when facing harassment or human rights claims, but she also helps the public by conducting seminars and appearing in the media to raise awareness about the legal duties of employers to their employees. We also are joined by Stuart Rudner, who brings to today's show a wealth of legal experience in employment law. He's recognized as one of Canada's top legal social media influencers, has authored a critically acclaimed book, You're Fired, Just Cause for Dismissal in Canada, and chairs and speaks at a variety of conferences, sits on numerous educational boards, and is a prolific volunteer in the legal community. Welcome, Sheryl and Stuart, and thank you for coming on. That is a mouthful, but I'm very happy to be back for season 2 because one of the things that we got a lot of feedback on is that you provide information in an area that's just not clear to the average person. You know, not everyone goes to law school or is unlucky to go to law school like us. So one thing that I think is really critical to understand, and we'll do a little bit of Stuart and then I'll throw it to Sheryl, is labor, employment law. Is there a difference? What's the difference? When was there ever a difference? So perhaps, Stuart, you could talk a little bit about the legislation, and then we could also then have Sheryl explain out any of those certain things as well.
Yeah, absolutely. It's a great question because I often get calls from people looking for a labor lawyer, or I get referred to as a labor lawyer, and I call myself an employment lawyer or an HR lawyer because the difference is very simple. Labor law refers to those who are unionized. Employment law is non-unionized. I deal strictly with those who are not unionized and do not have collective agreements, don't have arbitration, grievance procedures. They're governed by Employment Standards Act, they're governed by Human Rights Code and a whole bunch of other pieces of legislation, but they're not governed by a collective agreement. They don't have a union representing them. So the basis of the law is the same. But in many respects, their rights, their obligations, and their options are quite different. So when I get a call from someone who is part of a union, I usually have to tell them that in most cases, we can't really help them.
And well, Sheryl, you do both union and employment. And perhaps you can tell us what laws apply to someone who's under a contract, under a union situation, as opposed to someone who's in an employment contract situation?
Well, what the difference would be, when someone's unionized, they have their collective agreement, which basically is their Bible. But when you have the collective agreement, you also have all of the employment legislation that applies. So you have the Employment Standards Act, you have the Human Rights Code, you have pay equity, and all the employment pieces of legislation still apply to unionized employees. And if they haven't been incorporated into the collective agreement, it's deemed to be in there by the case law. And so it's assumed, the original case was Perry Sound, but so it's been interpreted so that all of the employment legislation applies to a union employee. The only difference and the big difference is that unionized employees have collective rights. It's what's under the collective agreement, whereas the individuals who are under employment law have the common law. They have wrongful dismissal. Unionized employees can't sue individually. They can't go after their employer for things outside of the collective agreement. They have to use the collective agreement arbitration process and the grievance process in order to bring their complaints forward, including human rights cases.
Including human rights. So human rights law would apply in both scenarios.
Absolutely.
Yes.
Well, and actually, Sheryl hit on a really important point, which is that people who are governed by a collective agreement can't bring a claim on their own. And I often get calls from people who are part of a union and don't feel like their union is representing them fairly, and they want to retain their own lawyer. And what I often tell them is I can advise them, but their legal representative is the union. And if they're not being represented properly, there's a whole process they have to go through in order to help themselves.
Well, and that's an unfair representation. They can go to the labor board, and either with or without the help of counsel, the forms are online, and they can make a complaint, but they're very hard to win. And at the end of the day, the union either has to act in a bad faith arbitrary or discriminatory manner.
What
And
does bad faith mean? So we always throw these terms around, but what does that really mean? What is bad faith?
Well, in the union context, it's again very difficult to prove because it's basically not turning your mind to the issues and not trying to deal with it.
Okay.
And whereas arbitrary is you don't like the person, you've decided you're just not going to do it, right? And so with the bad faith is that a union can do it wrong. They don't even have to do it competently, but as long as they do it, then you can't win one of those claims against them.
So even if they don't really do a great job at it and they kind of do it lackadaisically and...
But no union likes to have a Section 74, an unfair representation allegation made against them. So usually in and of itself, bringing those or threatening one of those is helpful to get the union to move things along.
Okay.
Because of what they do and what their message is and what their mission is. That if they're not and there's potential for bad publicity, then they usually will try to address things.
Well, media does a lot of stuff. It motivates a lot of people. Well, speaking of media and social media, I think we'll start with the interview phase. I'll have Stuart run with this one. We have a few minutes before our first commercial. But one thing let's start with the interview process. Social media, is that allowed to be used as a way to weed out those that you don't want working for you? First, we'll start in the employment sort of context and then the union. Go ahead, Stuart.
Sure, and I get this question all the time, and it's fascinating to me that people in HR who are relatively seasoned will call and say, like, am I allowed to go on Facebook? Can I do a Google search on the applicant? And they're almost scared that somehow it's illegal to do that. And I tell them all the same thing. There's nothing wrong with doing that. If there's publicly available information, it's open season. But I also tell our clients to be extremely cautious.
Why?
A few reasons. I mean, the hiring process generally is a bit of a minefield. So the other thing I tell our clients is you don't want to know any more than you have to. So because human rights comes into play, and you can't discriminate against people on a variety of grounds, such as disability, religion, ethnicity, etc. So you don't want to know. You don't want to know that the applicant has cancer or is trying to get pregnant or is from a certain country. Because if you know that and then you choose not to hire them, they can turn around and say, you didn't offer me a job because I had cancer. So what I always tell our clients is this: do the Facebook search or the Google search, but don't have the person making the decision do that search. Get someone else to do it, prepare a report,
a filter
out all of the information that's not relevant, and then you make your decision. Document all the reasons why you chose not to hire someone, as well as why you hired the successful applicant. And then you're in a good position to defend a claim of discrimination.
I feel like in the legal world now, we've like infiltrated everything. You have to document. So that's a great thing. And we're going to talk, we've about a minute left, but I want to jump into the union context. And when we come back, I want to pick up again on this topic because I think there's some interesting things that people need to know about as well. But in union, same scenario, or is it?
It would be exactly the same scenario. And the one thing added on top of that, which happens for employment law too, is that if employees calling in sick and saying that they're not at work, and then they end up going out skiing or to a ball game, and there's a recent case where employee actually asked for a sick day, didn't get the sick day, and then went ahead and went and pitched the game, and the employer, the manager, was suspicious and went out.
Pitched the game.
Yeah. And went out and actually caught him in action but didn't tell him. And so, I know employees who've lost grievances because they lied about where they were and then they put it on Facebook as to what they were doing.
And with that, it's a break time and we'll come back. When we come back, you'll not only watch lawyers do something incredible, give away legal advice with no bill, but you'll also get the insider tips you need in order to deal with any workplace issues and disputes. We'll be right back. Welcome back to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. We are joined today by some of Toronto's best employment labor lawyers, and we are answering your legal questions about anything to do with the workplace, from getting hired to doing the firing. If you have a question for Sheryl or Stuart, give us a call at 416-446-7090. So back into the hiring, interviewing process. I know a lot of kids right now are students that are hunting for jobs, and it's a little bit unclear what can be asked, what cannot be asked. And Sheryl, we had you speaking last. We'll go to Stuart and Sheryl. We'll do it that order. Stuart, go ahead.
All right, sounds good. Actually, one thing I'll mention off the top is the Human Rights Commission of Ontario actually has a great guide on the website of examples of things you can and cannot ask, dealing with all the different grounds of discrimination. So that's a great place to start.
Yeah.
But as the advice I give my clients goes back to what I said a few minutes ago. You don't want to know anything more than you have to.
That's it. Right.
And as people, we all have this habit. You bring somebody in for an interview and you want to put them at ease. So you ask chit-chat type questions. Where are you from? Are you married? Do you have any kids? And all of these things are minefields when it comes to human rights. So I try to coach our clients never to do that. And when I work with clients, we often role play, and I'll pretend to be the applicant for the job. And I'll come in, and you can see people are really holding back to stop from asking those questions. It's very awkward. Or to a point Sheryl was making off screen a few minutes ago, even if you start talking about yourself and you say, well, I've got 2 kids and they're in this school and that school, it almost prompts the other person to start talking about their life. So you haven't asked them, but indirectly you've prompted them to talk about it. And now that you know that they have kids or they're trying to have kids or what have you, and you don't hire them, it can be used against you. And it was funny because a lot of the clients I work with, I really work with them to have policies and procedures on how you do this.
Yeah,
and about a year ago, I went to visit a client, a large multinational, and they had really good policies and really good procedures. And they had one supervisor who just would not follow them. And his rule was, if I'm going to interview someone to work in my group, I want to have that first meeting. And I'll have them in. We're not going to call it an interview. We're just going to call it an introduction. And I want to meet him or her and take them around the plant and just kind of see how they respond. And he fought this, and HR said no, but eventually they were overruled. And the first time he did it, he was walking this man around the plant, and the man was obviously not a young applicant. And the first thing he said was, so, how long have you been in the business? You seem like you're a bit older than most of our applicants.
Oh dear. Did that blow up in his face afterwards, or were they lucky?
They seem to have gotten lucky.
Okay. Okay. Not advisable.
No, definitely not.
You know,
It's always good to have your prepared questions ahead of time and have the same questions for all applicants. And then also have a weighted answer system as to what you're looking for the responses and what's a good answer, so that you can actually, if you need to, defend your hiring decisions based on the fact that everyone was asked the same questions, you're looking for certain answers, and to also keep in mind when you're drawing up the questions and getting the answers, to realize there's different cultural values as well for the different people that you're interviewing.
what would be an example of that?
Some backgrounds believe much more in being modest than others, and so there'll be certain backgrounds where they'll downplay or not emphasize their positive qualities or their successes, because that's considered to be rude.
Oh, okay.
And so you have to keep that in mind when you're interviewing different applicants as well, as to what their responses are, because some may be rather modest in their responses, but doesn't mean they're not accomplished.
Well, how would you sort of navigate that? So, because I would imagine that would be perhaps a human rights claim. So
Well,
have you
it's
seen
just not
that
to
happen?
yeah, I have seen it actually happen, and so it just not to undervalue a modest response.
Okay.
And to recognize a modest response for what it is, and maybe perhaps to ask a few questions to flesh it out a little bit, but not just to make assumptions about shyness or lack of personality or lack of confidence. It's not that at all. It's just different cultural values.
Absolutely.
On the same topic, eye contact is another one. Some cultures, you don't look people in the eye. It's disrespectful.
And body space.
Exactly. But I've also heard people say, well, I didn't hire them because he seemed a little shifty. He wouldn't look me in the eye. So you've got to be very careful.
Oh yes, it's very interesting because Canada does have a lot of fantastic different cultures, and you have to be aware of that, and be sensitive to it, which is, well, why we have the Human Rights Code in place. And I believe we might have a Facebook question coming up, but as that sort of gets ready, perhaps we can talk about the Human Rights Code and what are grounds of discrimination. Actually, is the Facebook, I think I saw it pop up, but then it disappeared on us. So maybe we'll go with Oh, there it is. And after that, let's talk about the Human Rights Code a little bit and how that works. So Steve says, I work in construction as a bricklayer and frequently lift heavy things. I'm constantly in pain and have asked my boss to get someone to help. He's refused on the basis that it isn't a law that makes him. Is that true? So it looks like a few things. So help and then pain and asking someone to help. So let's pretend it's an employment scenario. Because it's not clear to me if this is a union or not. Non-unionized scenario and then unionized scenario. So Stuart, go ahead.
Sure, and I think the answers are pretty similar other than the union involvement. But I mean, when it comes to accommodation, which is what this is all about, so he's claiming he has some sort of disability. He's asking for accommodation. So I guess to answer the simple question, is it true? No. Of course it's not true. The employer has to accommodate if there is a legitimate need.
To the point of undue hardship.
The point of undue hardship.
Which we'll discuss. Undue hardship. That's all these words that we throw around.
Yeah, which I'm not sure anybody really knows what that means. We'll talk about how we approach it. But I mean, the onus is first on the employee to come in with medical documentation to show what needs to be accommodated. You can't just go to your boss and say, my back's sore, I need you to do something. You've got to bring in some sort of documentation that sets out what the limitations are on your ability to do your job. Whether it's being able to lift or not being able to sit or not being able to drive, whatever it is, you have to have medical documentation showing what the limitations are. Once you do that, the onus shifts to the employer to assess whether they can accommodate, and to Sheryl's point, to the point of undue hardship. So what that will mean essentially is it's not to the point of not to the point of impossibility. You don't have to invest millions of dollars to help one worker do their job. You don't have to create jobs just to accommodate someone. But you might have to shift duties around, or if it's someone like Steve who has to lift things, maybe there are certain things that are not so heavy and others that are very heavy. Maybe you have other people lift the really heavy ones and Steve does the lighter lifting. It will depend very much on the nature of the organization. So a large multinational is going to be expected to go a lot further than a small mom and pop shop. Cost is one of the largest concerns, but there are other issues as well that they'll look at. But the simple answer is, from an employee point of view, put together the documentation to show what your limitations are. And from an employer point of view, don't just brush off the request, because that will pretty much automatically be seen as a failure to accommodate. But seriously consider whether you can accommodate. And when I say seriously, I've seen employers who just look at the medical documentation and say, oh, we can't do that. And that's the extent of their assessment. You have to show and justify your decision by showing that you really considered what options there might be, and then you decide either we can or we can't. The employee is not entitled to their preferred solution if there is some other reasonable accommodation available. It's up to the employer to find something that's reasonable or decide that there is nothing that would be within the realm of undue hardship.
And Sheryl,
and it has to be on an individual basis as well, because what might have worked for one employee and say, well, I can't do it this way because for Johnny I did it this way, and Steve wants it this way, but we only do it the way that we did it for Johnny. Well, you can't do that. And so what the code requires, and they also have good
the code.
The Human Rights Code.
The Human Rights Code, okay.
What it provides and requires is that you look at each individual request for accommodation individually. It might be the case that something that they come up with as a protocol or a plan does work for others, but you can't just apply it blanket across the board. It has to be individual for each individual person. And also to throw in with regards to its accommodation, but it's also potentially with regards to occupational health and safety. Every employer has to keep their employees safe and prevent harm. So, that's one of the things that has to be looked at too. How much is he lifting? Is it a job that should have two people?
Restrictions? Like are there legislated restrictions, like person X weight can't carry?
It comes down to reasonableness too, right? They're not going to put everything into the statute, because then then it becomes inflexible and hard to manage, right? But if it's very heavy things and one person, any reasonable person would be injured doing that job, then it probably should be the case that if they don't have the employer looking at it, then occupational health and safety can come in and do an inspection and say, no, this is a job that should be done by two people.
Okay.
And they do audits and they do assessments as to looking at the task and looking at the jobs to see whether or not it's reasonable.
And we have someone patiently waiting on the phone, because next I want to ask how would they escalate, which is an interesting question. But we have Mike from Toronto who's Mike, who's right here right now. And Mike, you're online. You go ahead and ask. Oh, Mike hung up, unfortunately.
no.
We held him on for too long. We were talking too much, but hopefully Mike comes back and perhaps he answered his question. But perhaps we can go back then to this scenario with Steve. And one thing that we want to talk about is, okay, so let's say I get my documentation in order. I say, employer, look, and they say, well, we can't, or we don't, they just dismiss me, or I feel as if they're not really taking into consideration my concerns. What do you do next? Perhaps we'll start in the union sort of context and then we'll move into another.
If it's the union context, you go to your union and you advise them that you have this issue and this concern. And either the union will try speaking to the employer or they'll file a grievance. And once the grievance is filed, and it's up to the union whether or not a grievance gets filed. You as an individual, can't pursue it on your own. It has to be through your union. And then, usually as part of the grievance process, it'll be set on the collective agreement as to what the stages are. And if you're not able to resolve it, then it'll go to an arbitration.
Okay.
And either go to a board, a single arbitrator, or potentially it'll go to the Ontario Labour Relations Board as an expedited arbitration so that the Labour Board will decide the grievance.
And Stuart, in the non-union context?
Yeah, so if you don't have a collective agreement in a union, then you would be entitled, if you're being discriminated against or not accommodated, you're entitled to file a claim pursuant to the Human Rights Code. And you essentially have the option now. You can bring a claim to the Human Rights Tribunal in Ontario, or if you can attach it to another claim, like for example, a wrongful dismissal claim, you can bring those together in civil courts. And that's often more advantageous because you can bring both claims together, and you can seek much more significant damages from a court than you can from the Human Rights Tribunal. So in many cases that's more advantageous, and you get legal fees.
You don't in the tribunal?
No.
Tribunal you don't. Now the flip side to that is in the tribunal you don't have to have a lawyer. In court you can go unrepresented too, but it's a lot more challenging. The tribunal you don't have to have a lawyer, and they have lawyers that will assist you in the process. So there are contexts where it makes sense to go to the tribunal, but in many cases it's going to be better to go before the courts.
And you can't ride two horses, so it's one or the other.
Yeah. So meaning that I can't go to the Human Rights Tribunal, that doesn't work out, maybe I'll sue you in civil court. You can't do that.
People have tried, but no, you can't do both.
You can't do
You used
both?
to be able to do both, but they've prevented that through specific language in the code saying that it's one or the other.
Okay. Yeah.
Now, what's interesting now, and hasn't been tested yet, is the Human Rights Code allows for reinstatement, in addition to just damages for wrongful dismissal.
And that always happens in unionized.
Yeah, so in your world that's normal. For
and
me,
we'll
that's
talk about
not.
what reinstatement means. Well, what does reinstatement mean? What is that?
Return to work, and often return to work with back wages and benefits and pension and everything that you lost in the meantime if it was found to be completely unreasonable. However, if the arbitrator finds that the employee was due some discipline for the misconduct and something should have been done, but it shouldn't have been the capital punishment of labor and employment law, which is a termination, then they might give them a month unpaid suspension, or different things where they might get some of the back wages back, but not all of them. And sometimes it takes a long time to hear a arbitration. And so just as there is in employment law, in labor law now too, there's also the idea of mitigation. You have to try to lessen your losses. You can't just sit at home and wait till your grievance is resolved and the arbitration is done. You have to actually try to go out and find a job in the meantime.
But what if you want to return back to your job?
You can still return. You'll just have to give up the other job to return to your job.
Okay, so let's say you're in that scenario and you're sitting and you're being interviewed, let's say by an employer. Do you have to disclose, I have a claim that's going on right now and I might go back to my old job?
No.
I don't think you'd have to, no.
No?
But this whole notion of reinstatement is foreign to the employment law side of things, because at common
Except for
law,
employment standards.
employment standards, yes, but at common law, if you bring a wrongful dismissal claim and you're successful, you can get money, but you would never be reinstated. Now the Human Rights Code says you can be, and you're allowed, as I said before, to bring a human rights claim before the courts. So it's open to judges to say, we find that you were discriminated against in breach of the code, therefore we're reinstating you. No judge has done it yet, but it might happen.
Well, now that we're on the topic of wrongful dismissals, getting terminated and fired, let's talk a little bit about some scenarios that tend to come up when we see a wrongful dismissal claim. or perhaps we could talk about constructive dismissal as well. But first of all, one question that I always get is, look, I was a little bit tipsy and I showed up to work. Does that justify me getting fired immediately? Perhaps, Sheryl, we could talk about that. That I hear that a lot. You know, I was smoking weed. You know, I came to work and I got fired. Is that allowed?
Well, the first thing that an employer should always look at in that context is whether or not the employee has a disability, whether or not he or she has a drug or alcohol addiction. And if that's the case, then no, if the employer assumes that to be a place or has reason to believe that that's the place and what's going on, then the place that the employee is in, then no, they can't terminate them. They have to accommodate them. And you know, it depends also what policies the employer has in place if there isn't a disability or perceived disability. It also depends, is it a safety sensitive position? Is it something where they're going to be putting the public or children or somebody else in harm? What's the nature of the job? What is their discipline record? What else have they done? And have they done this a number of times? Has progressive discipline been applied?
Yeah.
And have they not learned from their past discipline and to the point where the relationship becomes untenable because the employee is refusing to learn from the error of their ways? So for the first time, no. But if it's that they've had progressive discipline applied and they're not learning and they're ignoring their employer's warnings, and employers also have to say when they're coaching them that if you continue to do this, your job is in jeopardy.
So that's something that an employer has to do.
Yes. Yeah, because if the employee doesn't know, there's also the potential argument that it's been condoned, or that it's not that serious. And a lot of employers like to just do verbal warnings.
Yeah.
A lot of them seem to have a really hard time, I don't know if you find this, writing things down and putting written warning letters out and doing the unpaid suspensions, because the whole idea is you escalate the amount of punishment or discipline that goes with the action so that they understand that their job is in jeopardy. It gets more and more serious until the ultimate penalty happens, which is the termination. And so, just keep on providing verbal warnings isn't going to be sufficient to let the employee know their job is in jeopardy.
And something that you sort of raised, and perhaps Stuart, you could talk about a little bit, is that addictions. Is that a surprise? People are very surprised to hear that it actually falls underneath the code, and that's a grounds of discrimination. So, in the employment context, if you see someone that consistently shows up to work drunk, let's say it's not going to damage somebody, so they're not in a position where they can hurt somebody by virtue of them being intoxicated. What happens in that scenario? Because now you could be discriminating against them if you fire them, if you will.
Yeah, no, it comes up fairly often. And I mean, to Sheryl's point, I mean, if you're the employer in this case and you've got someone who comes in once or twice or regularly and they're intoxicated in some way, then, and you can look at your policies and everything else, but you should be able to discipline them.
Okay.
So that's step one, is that there's been some misconduct, you should be able to discipline them. Whether you have just cause to fire them is a whole other issue. And as you mentioned in my intro, I wrote a book on just cause for dismissal.
Yes.
I've read a whole lot of cases on the subject. And one thing that most employers, most employees don't realize is you don't just look at what the person did in isolation. Yeah. So take your example. The person came in to work drunk. So once you've accepted that's a fact, then you can say, okay, discipline's appropriate. Is dismissal appropriate? Then you look at what Sheryl was mentioning. You look at the whole context.
Does everybody else come in drunk too?
Yeah,
that's one factor.
Really?
But you take a contextual approach. So you look at the whole history of the relationship. Have they been in trouble before? Have they been disciplined before? Have others been disciplined? Is everybody else coming in drunk, to your point? Is there a permissive workplace? And you also look at the person's position and what is the nature of your expectation. Do you need to be able to trust them to come to work sober or not? Are they driving a truck? You look at all those things and then you assess, has the relationship been irreparably harmed or is some lesser form of discipline appropriate? Could it be a warning, verbal, written, suspension, etc.? You look at all those factors, then you assess, do we have just cause to fire them? And like Sheryl said, it's often called the capital punishment of employment law. So I always tell people just cause is not a lost cause. You shouldn't be scared to fire someone for cause.
Yeah.
But you have to approach it very cautiously and then add to the mix disability.
Yeah.
So now if you think the person might have a disability and they are addicted, you have to think about that too. And if you discipline them because of it, then you may have breached the Human Rights Code.
What I always say to employers when they go into, I coach them before they do their coaching for their employees, and I say to them, always give them an opportunity. Ask them, is there something going on that we need to know about? Is there something you want to talk about? Is there something that we can help you with? To give the employee the opportunity to come forward and say, I need accommodation, I need help, I need assistance. Because employers too have to be careful that they can't assume that someone's addicted and that someone has an addiction, right? But they do have to give ample opportunity to assist someone in case that is what's going on in the place that the employee's in.
There are some great cases out there where people were fired and the employer assumed that they had a disability, that they were addicted to drugs or alcohol, and they sued for discrimination. And the courts and the tribunals have held that disability includes perceived disability.
Yep.
So you can be discriminated against even though you might just be a casual drug user because you were perceived to be an addict.
Yeah.
Oh, that's an interesting one.
And I mean, it also implies when someone has suffered from depression or from cancer.
Mental health,
Yeah, mental health is always a big issue. And so once someone's had an episode of depression, that the assumption is that they'll always be depressed, which isn't the case. And so it may have been a place in time, a temporary disability that they had, and it might have been from circumstances in life. Different things happen to people, but when it's assumed that this person is disabled and they don't want to have to deal with that on an ongoing basis, then if they let them go, because of that, and it's one of the factors that they take into consideration in making the decision to terminate, then that's a perceived disability at that point in time, not an actual disability, and employees are protected under the code for that.
One thing that I find, again, we always throw a lot of language around, and I find sometimes you hear overlap in language. So going along the vein of dismissal and so on, perhaps we could talk a little bit about what's the difference between saying I got laid off versus terminated. And then we could also talk a little bit of termination for cause or not, and how that applies also in the union context. So perhaps the difference between getting laid off and so on, and then I'll have Sheryl sort of pick up on the rest of that.
Yeah, that's a good question. Actually, in my book, in the introduction, I talked about this because we have so many terms we use, and laid off for most people means that basically you were dismissed, but without cause because of the economy or whatever. Whereas if you were fired, you were dismissed because you did something wrong. So we talk about laid off, we talk about being let go, we talk about being fired, terminated. And I always tell my clients, we don't terminate people. We terminate their employment.
Yes.
This is not Arnold Schwarzenegger. So that's one thing that I try to avoid using. I use dismissal, not termination. But it's important to understand that whatever it is, if you're dismissed, let go, fired, whatever, all you're assessing is that the employer have cause, in which case you are not entitled to any notice or severance at all.
How about like any sort of monetary compensation, bonus, stuff like this?
I mean, if there was just cause, then you're entitled to be paid for all the time you worked and accrued vacation pay and that kind of thing, but that's it, nothing more. Otherwise, and just cause is probably 1 or 2% of dismissals in Canada at most.
Really?
And just because you have a just cause doesn't necessarily mean you have willful misconduct or willful neglect of duty or one of the other conduct that exempts people from coverage from the Employment Standards Act. So someone can be terminated for just cause but still be found to be entitled to termination and severance pay under the Employment Standards Act.
Why is that?
That's
different test.
It's
totally
a
different
very different definition. You're right. There was a great case about 2 years ago now where somebody was fired for cause, and it dealt with like absenteeism and things like that.
Okay.
And so
that's cause.
And what the court found was it was just cause at common law. So he was not entitled to any notice at common law. But Employment Standards Act says you get notice unless there's willful misconduct.
It has to be intentional.
Yeah, and what the judge said essentially was this guy was careless, but not deliberate in his misconduct. Therefore, he got the statutory notice, but not the common law notice, just to confuse things a little bit more.
And Sheryl, the difference between statutory and common law notice would be?
Quite a bit. Statutory Employment Standards Act, each employee, if you've been working for at least 3 months, under 3 months, you're not entitled to anything under the Employment Standards Act. 3 months to 1 year, you're entitled to 1 week. 1 year to under 3, you're entitled to 2 weeks. And then 3 to 8, it's per completed year of employment for termination pay or notice, written notice of the termination. And then if you work for an employer and you've been there for 5 years and the employer has a payroll of $2.5 million or more, then you're entitled to severance pay.
So you need a lawyer to tell you. Wow.
Yeah,
Wow.
and it's up to 26 weeks. But with severance pay, it's completed years and completed months, so you get fractions for it. And so, you know, if someone's been working for 10 years and 10 months, then they get and the employer has the 2.5 payroll, then they would get the 8 weeks termination pay, because that's your maximum, and then you get the 10 weeks plus 10 over 12 for severance pay. So
It's very complicated. And one of the unfortunate things is when you call exactly when you call the Ministry of Labor, and I've had employers do this. So they call and they say, we have somebody here, she's been here 6 years, we have to let her go, there's no cause, what do we give her? The ministry will only talk about the Employment Standards Act. So they will say 6 weeks. And I've had clients who said, oh, okay, and they give 6 weeks, and they were sued for wrongful dismissal for the common law reasonable notice. And then they come to someone like Sheryl or myself, and they realize that they actually have liability, even though they called the ministry and did exactly what the ministry said. So it's very challenging.
And reasonable notice is what is reasonable in that person's circumstances to find a new job. So what we look at is their age, their position, their reemployability, and assess,
And
as a court would
service
assess.
also.
Yeah, and length of service is a big one, as to their entitlements. You know, what a lot of employers will try to do is have an employment contract that has a termination clause in it that will limit liability to the Employment Standards Act.
Okay.
And so that's one thing for employees always to look at when they're going to sign an employment contract.
Within the same circumstances, the same rules would apply in a union context?
In a union context, well, even to go back to the original question as to what's a layoff versus a termination, under the union contracts, usually, because under the Employment Standards Act, to start off with, because that's the base minimum for everyone, including unionized employees, that a layoff can be 13 weeks in a 20-week period as a temporary layoff under the Employment Standards Act. And then there's also, if it's 35 weeks in a 52-week period that someone's on layoff, that's temporary. But it also could be temporary because under the union contract, they'll negotiate recall rights.
Oh, okay.
And that's always a big one. And the unions are always looking for 1 year, 2 year recall rights, so that the job gets held on for the employee, hoping that in 2 years' time that there's going to be work and they're going to have a job to return to. So it's a layoff until then, and it's only when the recall rights expire that the employee is deemed to be terminated and then entitled to their employment standard or whatever is negotiated into the collective agreement as to their entitlements upon termination.
This is something that often causes confusion as well, because the Employment Standards Act says if you are going to lay someone off temporarily, here are the limits, the 13 weeks that Sheryl mentioned. If you go beyond that, it's a permanent layoff or a dismissal. The problem is that the Employment Standards Act doesn't necessarily give you the right to lay someone off temporarily. That has to be contractual. So if it's in a collective agreement, that's simple. If you have a contract of employment that says we're hiring you, here's your salary, your vacation, et cetera, and we have the right to lay you off temporarily, then you're okay and you can follow the act. But if that's not in a contract or it's not implied, for example, construction industry, it's kind of known you're going to be laid off in slow times.
Right.
But if it's not in your contract or implied, then you as an employer don't have the right to temporarily lay someone off.
The courts consider it a constructive dismissal.
What is this constructive dismissal? That's another term that we throw out there. What would be?
It's surprising how many people know what that is.
You're right, actually.
Or think they know.
Or think they know. That's true.
So what do people think they know, and what is the reality of a constructive dismissal scenario?
Well, when it's the temporary layoff, the whole idea for an employment contract is you have the exchange of labor for payment. And if you're on a temporary layoff, you're not giving your labor and you're not getting paid for it. So there's a fundamental breach in the employment contract, right? But generally with constructive dismissals, what it is that usually it involves, there's two big versions of it, or forms of it. One is with regards to a unilateral change of a significant term and condition of the employment. So that can be hours of work, it can be location, it can be job duties and responsibility, it can be compensation. And if a significant portion of your job or your responsibility or your pay is taken away, or suddenly you go from a day shift to a night shift, that would be a constructive dismissal.
And that applies in a union context?
That doesn't apply in a union context.
It's only in employment context.
That's employment context.
Yeah, it's
and then the other
different.
one is with regards to creating a poison work environment and making it so untenable that the employee couldn't possibly continue their employment relationship because of the working conditions.
Well, going along the vein of workplace conditions, everyone's talking about violence and harassment. I believe there was a bill that was introduced not too long ago regarding workplace harassment and violence and so on.
It's a couple of years ago now.
Yeah,
but
Bill
168.
Yeah, 168, you got it. Could you perhaps talk about that, Stuart, a little bit, how that has influenced now the duties of an employer?
Yeah, I mean, Bill 168 came about because of a really unfortunate situation, I believe in Windsor, of a nurse who had a personal relationship with a doctor. She broke it off. He kept trying to get back with her. She wanted no part of it. She was scared to work with him. The first time they were on shift alone together, he killed her. So our government reacted, or some would say overreacted, and instituted Bill 168, which is designed to augment the Occupational Health and Safety Act by...
But I thought people knew that there was a violent relationship between the two of them as well.
I think
it was
known, but
yeah.
And that's where Bill 168 tries to get at, not just saying the workplace must be safe, you can't have floors that are uneven or railings that are loose or that kind of thing. It goes way beyond that and says as an employer, if you become aware of, for example, domestic violence that might impact the workplace, you have a duty to take action, reasonable action, to protect your employees. Or if you become aware that one of your employees has a history of violence that could impact the workplace, again, you have a duty to take action. You also have a duty to be proactive and do a risk assessment of your workplace and assess any risks that might apply to your workers. Are they carrying a lot of cash? Do they drive alone at night? Are they working alone? Are they going out to visit customers? Is there anything that might cause there to be risk? And then you have to adopt policies and programs to minimize that risk. So getting back to the violence situation, if you become aware that your employee has a violent spouse that might spill over into the workplace, you might have to, kind of like the old post office joke, have a picture of them at reception and say, this person is not allowed in. Or you may have to make sure that employee is not walking to their car alone in a dark parking lot. Or you might have to change their shifts or change their location of employment or do whatever is reasonable to protect them. All of that is new under Bill 168.
And it applies in both the employment and the unionized context. And when there's been a lot of cases, and probably I would say more cases from what I've looked at in the unionized context than in the employment context as to application of Bill 168.
Okay.
One of the recent ones was whether or not the employer had just cause for terminating an employee who was on the picket line and who had said in the earshot of the security guard, but not to the security guard, "I wish I brought my gun."
Ooh.
And so the employer, of course, took it very seriously, terminated the employee, and relied on Bill 168, and that being workplace violence. However, the evidence of the security guard was, I didn't feel threatened. I didn't take him seriously. Like, it was part of the picket line context and the situation, but I didn't feel threatened. Well, if he didn't feel threatened, then there wasn't workplace violence that would justify the employee being terminated, and so he was reinstated.
Yeah,
Contrast that, though, with another case, and I'm going to talk about a labor law case now. The first Bill 168 decision involved the City of Kingston and CUPE, I guess it was. And you had an employee who had a history of anger management issues. And she was having an argument with her union leader, I believe. And not surprisingly, she was getting kind of heated. And she referred to a colleague of theirs that had passed away. And the union leader said, "Don't talk about," I think it was Jim or Bill, "don't talk about Bill. He's dead." And she responded, "Yes, and you will be too." Now that can be interpreted in a lot of ways. And it's certainly not as serious a threat as "I am going to get a gun and kill you." But it was perceived as a threat. She was fired, she grieved, and the arbitrator had to assess whether this threat was just cause for dismissal. And what the arbitrator did was take Bill 168 into account, and what she said was, in the past, that threat may have been pretty low on the spectrum of severity. under Bill 168, we now have to take it much more seriously. And she put it at a much higher level of severity and said an employer has this duty to protect employees. They have to take the threat seriously. And in that case, the arbitrator said even if the quote-unquote victim does not feel threatened, even if the person making the comments has no intention of carrying them out, despite all those things, in that case, just cause was found, which is a very different result than the case Sheryl talked about. And so the cases are still working themselves out, but threats are definitely been taken more seriously now than they were before.
Well, we got about a minute and a half
But
left.
bullying, not so much.
I was going to say, we've got about a minute and a half left, so perhaps, Sheryl, you could throw something in there about
Sure.
bullying, you were saying?
One of my disappointments is because there is a lot of bullying in the workplace.
Oh, yeah.
Over, like I'd say, the last 5 years, I don't know if you've had the same experience, but more and more people, even before the legislation came in, was saying, you know, that they're experiencing bullying. And bullying can be bottom up, top down. It can come from laterals, like people who are your coworkers. It can come from anywhere in the workplace and still constitute bullying. It doesn't have to be your supervisor bullying an employee for it to be bullying. Employees can actually, and I had a situation where it was employees who were bullying their supervisor and their manager,
wow.
and actually causing their managers to go off on sick leave. And so it was a revolving door because they wanted to be in control and they didn't want someone in control. And so they kept putting their managers out on disability leave by creating a very stressful environment. This is before Bill 168. And a lot of managers feel ineffective in those circumstances. But I find Bill 68 doesn't really have teeth when it comes to bullying as much as it does with regards to violence. So it hasn't seemed to paid off with regards to the bullying, but it has with regards to the violence, definitely.
Great ending, because guess what? Next break. And when we come back, we will continue to help make the law a little less murky by answering your employment and union law questions and helping you protect your rights when on the job. Welcome back to Toronto Speaks Legal Advice. I'm your host, Natalka Faulkner. We are joined today by employment lawyer Stuart Rudner and employment and labor lawyer Sheryl Johnson. And before the break, we were discussing your rights and how to avoid common legal mistakes that arise when on the job, managing difficult employees, and even deciding whether or not to join a union. If you have a question for Sheryl or Stuart, give us a call at 416-446-7090. And I do know that we have a bunch of Facebook questions that we should get to, so we're going to go straight to one right now. And we'll see how we can help some other people too. If not, we have a lot more to discuss. And there's the question. Oh, and it disappeared on us.
There was a question.
There was a question. I work outdoors with someone who constantly smokes. I'm allergic to smoke and he won't stop smoking. What can my boss do? Isn't this an occupational hazard? So Sheryl, union, Stuart, non-union.
I wouldn't define it as an occupational hazard.
No.
Because it's nothing to do with the job duties and responsibilities, right?
Okay.
An occupational hazard would be, you know, if you work in a smelting plant and, and you know, there's high heat and the chemicals. And so it's not an occupational hazard. But, you know, the first step, and I think this is employment as well as union, is to tell the coworker, I'm allergic, please stop. Right?
The coworker, not the
coworker.
not the boss.
Not the boss. We start with a coworker. I mean, unless it's an unreasonable coworker, we go into the Bill 168 and you're going to get in trouble. And there's a chance of physical violence. But in the union context, you also have the ability to have the buffer and go to the union to deal with it, and but they have a hard time dealing with two members. They don't, you know, they don't like to get involved in the politics of it. And so, really, you know, but you have to go to your union. You're not going to the employer about the situation in the unionized context.
Oh,
You're
okay.
supposed to be going, you can deal with the employer, but at the end of the day, you as a unionized employee potentially is putting the employer in a difficult situation because they're not supposed to deal with you individually.
Okay.
They have to deal with you through the union.
So generally all union complaints, we should just maybe underscore that.
Yeah.
Always go to your union leader then.
Yeah,
Never
and-
to your employer.
Yeah, and one of the reasons for doing that is that any grievance, usually in the collective agreement, they have the grievance and arbitration procedures, and there's set timelines for everything. And so, you know, it has to be within 5 days or within 10 days of the event happening. If you don't go to your union, and the union is the one that is a party to the collective agreement and can file the grievance, if it's not done in a timely fashion, the employer actually has to agree to waive the time limits.
Oh.
So you want to make sure that you let your union know if you have any issues or concerns as soon as possible.
Okay. And let's say a non-unionized context, you have someone that's smoking in front of you all the time, and you so you haven't told them yet, you know, that you're
Right.
allergic.
Yeah, so I mean, you know, just common sense. Logically, you would tell the person first, unless you're afraid they're going to threaten or attack you.
Or be violent, yeah.
But otherwise, you would go to HR and tell the employer. And to Cheryl's point, I mean, occupational health and safety comes to mind when you read this. It's not quite on all fours with what that was intended to accomplish, but there is an obligation to provide a safe workplace. So arguably it would apply, but more directly, if you have an allergy, that's a disability. So they have
so a disability.
accommodation.
Okay.
so they would have the duty to accommodate within the bounds of undue hardship. So again, you go to HR and you explain the situation, and they should take some action to address it.
Well, you know, we're sort of talking about bullying a little bit before. We have only a couple more minutes until the end of the show, and there's so many things that I want to talk about. Quickly about bullying, how does that affect management? Because someone could now say, well, you know, she was criticizing me or he was criticizing me, let's say in the union context. You know,
Well, you see a lot of grievances that way where, and the arbitrators have said it quite clearly, managers are allowed to discipline and exercise their managerial rights. However, you have to do it fairly. You have to do it in a way that's not discriminatory. And you know, if it is bullying, then the grievance would be successful at the end of the day if the manager is a very harsh manager with regards to their management style. But just because you're disciplined doesn't mean you're being bullied.
Okay. Yeah.
Yeah, and another way of saying it really, there's a big difference between managing and bullying. And if you are correcting mistakes, if you're offering constructive criticism, if you're
not
giving negative
harassment.
reviews, even if it's only one person, but if they're not performing and it's legitimate and in good faith, that's not harassment, that's not bullying. But the flip side of that is even if they deserve to be managed, if you do it in an abrasive way, in an aggressive way, in a threatening way, that's bullying, and then you're over the line.
And you swear.
I know, yes, I know you've been
Never
my
Depending on the
yeah,
workplace.
yeah.
Never
Some
acceptable.
workplaces, that's the norm.
It's a culture, yeah.
Like
And-
law firms.
Yes, exactly. We also throw things apparently, right? But, you know, speaking of relationships, this is something that kind of was neat that came up. Cheryl, although it's not Valentine's Day yet, I'd like to talk about the love contract, and perhaps we could talk about a little bit about relationships in the workplace environment. Do it or don't do it, I don't know, but talk about this interesting contract that you were telling us about earlier.
Well, it came to be a situation where it was a small workplace. Because usually when two employees are in a relationship in a workplace, what you try to do is ensure that they're not in a reporting relationship with each other. And if they are, move them around, try to get them voluntarily to agree who's going to move. But I had a situation where it was a very small workplace. And so we didn't have that ability to take away duties and responsibilities or move people around. It was always going to be the case that the one of the two couple was going to have some supervisory duties and responsibilities over the other. So in order, because employers are often vicariously liable for the actions of all their employees, especially their managers and supervisors when they're managing and when they're doing it within the scope of their duties and responsibilities, we try to lessen their potential liability. So what I did in the circumstance was I created a love contract. And so basically what it said is that they're in a voluntary relationship and that they don't hold their employer responsible with regards to the fact that they entered into the relationship, and if the relationship should end, they don't have a claim with regards to a human rights sexual harassment charge. They don't have a claim with regards to a wrongful dismissal, but it also sets out the rules of the game as to expectations, as to who's going to be the one that's going to make decisions with regards to raises and vacation time, and we try to take that away from the manager or the one with the supervisory responsibilities so that it doesn't impact on the other employees in the workplace, because there's often, you know, claims of favoritism, and you know, it does have an impact on the morale of the other employees.
And we have about about 30 seconds left. Stuart, you got to add something to that. I'll give you the final word on the love contract.
All right. Well, what I always tell employees, or employers, a lot of them try to have policies saying no fraternization, no dating, and I would say it's almost impossible to control that. Instead, have a policy that says if you're going to be in a relationship, you can't have one person in the relationship with authority or decision-making power over the other. So you shouldn't have one of them granting raises, vacation, etc. And if you're the employee and you're in the relationship, don't lie about it. Don't cover it up. When I was researching for my book, it's amazing how many cases I read where the person was asked 3, 4, 5 times, "Are you in a relationship?" and they denied it.
And we gotta wrap up. That's too bad, though. We'll read the book. That's all the time we have today. Thank you, our viewers at home, for your calls and questions and comments. And thank you, Sheryl Johnson and Stuart Rudner, for helping Torontonians make sense of the law. Remember, know your rights. And if you don't, then watch us next time to get free legal advice. After all, the best things in life are free. I'm your host, Natalka Falkmer, and thank you for watching Toronto Speaks Legal Advice.